We start off with, I'm going to have trouble with this first name. Tyreus Carpenter. I don't think I've ever known anybody named Tyreus, but Tyreus Tyrone Carpenter, 23 CR 1821. No answer. No answer in the courtroom. I asked the bailiff to call into the hall. Good luck on it. Tyreus Carpenter. I want to go out and hear him do that.
So you got I know them so well. You know, you will try.
23 CR 1821.
And Judge, come see me for fingerprint.
Mr.
It's gonna be a bleep.
Carpenter, come on up, and you'll be fingerprinted first, and then come right in to see me. Spanking. 23 CR 1821 is called the State of Texas versus Tyreus Tyrone Carpenter, present with his attorney and the state's attorney. And Mr. Johnson, your firm is representing the defendant here. And does the defendant waive a formal reading of the indictment and arraignment? Can we proceed in summary?
Yes.
In summary, are you chewing gum?
Courtroom 101. Don't chew gum in front of the judge. It's basically the legal version of showing up to a job interview in pajamas. Respect matters, especially when your freedom is on the line.
Give him something. This is kind of like in church. Don't be chewing gum. There we go. In summary, this indictment alleges the second-degree felony, which carries with it up to 20 years in prison. So we don't chew gum, and we're talking about looking at 20 years in prison. On or about September 3rd, 2023, in Jefferson County, Texas, you committed the second-degree felony of aggravated assault, causing serious bodily injury. Do you understand what you were charged with here, sir?
Yes, sir.
Okay. Again, this is a second-degree felony, which carries with it a term of not more than 20 years or less than 2 years in prison. Also, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
It looks like the parties have agreed you would be pleading guilty to the lesser included offense of Class A assault, correct?
Yes, Your Honor.
Class A.
Basically dropping the serious bodily injury. It's just bodily injury, Judge.
Okay, you're going to be pleading guilty to Class A assault, which is defined as intentionally and knowingly causing bodily injury to another person, which carries with it up to 1 year in the county jail and or up to $4,000 fine. Correct? Is that right?
Yes, sir.
Do you understand the punishment range?
Yes, sir.
An agreement's been reached where you would be placed on deferred or unadjudicated probation for up to 2 years in length.
Yes, sir.
There is no fine.
That's correct.
Is there any restitution?
No known restitution, Judge. And I just
Really?
reaffirmed that.
Because on its face, it says serious bodily injury was caused,
Yes, sir.
and there's no harm. Nothing. Victim had to get stitches for the laceration, but he's never submitted anything.
That's correct, Judge.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this Class A misdemeanor, guilty or not guilty?
Yes.
Are you pleading guilty voluntarily and because you are guilty of this crime? Show you what's marked here as State's Exhibit 1. Did you sign that document? Show it to me, please. Did you sign that document voluntarily? Did you understand it, discuss it with your attorney, or the contents all true and correct?
Yes, sir.
State's Exhibit 1 is tendered into evidence.
No objection.
Without objection admitted. Among other things, this states you were mentally competent to enter your guilty plea, which is freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged and any lesser included offenses, such as Class A misdemeanor assault in this case. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You are totally satisfied with the representation provided by your lawyer. All true, so help you God.
Yes, sir.
States Exhibit 1, part of the record for all purposes. Pre-sentence report waived. Yes.
Yes, sir.
Okay, I'm going to follow this agreement and find you are pleading guilty today voluntarily. You were mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea to find you guilty beyond a reasonable doubt. But I am going to defer any finding of guilt and place you in deferred or unadjudicated probation for this lesser included Class A misdemeanor of assault. There will be, for 2 years, there will be terms and conditions of probation that are normal and customary. The probation office will see you here in a minute, go over it with you, you sign, and you begin probation. All right, go see the lady. Thank you.
Thank you.
CR 81, Jasmine Hall. Yes.
I need to come fingerprint.
You need a fingerprint from you.
Not taken.
No, I can redo this indictment and a third degree felony.
Sure.
And she admitted to it to the officer. Yeah.
It's racial right here.
What are we doing on this case? What are we doing on this?
Set it for trial.
Uh-oh.
Okay, stay in front of judge. I'm gonna read that.
Well,
Hey, Brian, I thought you said it was gonna be.
no, it's a trial. Here, stand right here.
Are you Jasmine Hall?
Yes, sir.
You don't dress like that again. You're wearing a body thong and then
Ouch. Fashion Police. Courtroom Edition. The judge is crystal clear. What you wear to court isn't just about style, it's about respecting the process. Question for you. Should judges care about clothes this much, or does it distract from the actual case?
you're trying to cover up your breasts. And I mean, you dress nicely. This isn't church, but it's like dignified. And this is important. This is the Constitution. We'll treat it like there's respect. What are we going to do?
Set her for trial.
Would you wear that to trial in front? Why not?
That's not a bad outfit for trial, depending on the
You know,
conversations.
you're the last guy that would on clothing. You're wearing white socks with the gray
I'm
side.
straight. I could see a jury where that might work, Your Honor. But I'm not. I respect what you're saying. You
All
just
right.
need to
Yeah, but
address
you know,
your
I shouldn't be talking to you like your parents. But that's you're missing the boat here. This is important and dignified. You want your best foot forward. The jury, you need to impress the jury that you appreciate the importance of the whole process, and that's dressing is you don't even have to talk. It's communication you're giving to others of what you think about the whole process, which is not honorable. Get a resetting.
Just dress like you go to church. Like that.
No.
You wouldn't wear that to church. Yeah, ma'am. Oh, whoa. Did you get a resetting?
Yeah, just
You got to get a resetting here.
cover on the resetting. Sorry, I thought it was gonna be a plea. No, you can.
All right. Sign right up it.
Elvin Bryant, 23-41373 is next call.
Oh, yeah, we were second already.
Oh, we did.
Yeah, okay, yeah.
Oh, Brennan will get the reset.
What are we going to do?
We need that based on $12.
Okay.
Here. Who's the attorney on this one? Elvin Bryant, please.
I'll stand in.
There's nobody on it.
It's Mike.
It's a state's. You can have a probable cause affidavit. I've got just an investigative summary, and I mean summary. One sentence. It just.
Judge, I would almost bet that this was referred direct to grand jury. And
We don't
I think the one thing we have is the expert summary from the medical doctor, Dr. Beach. What are we here for? Just an announcement?
This is.
He's putting it on the trial docket. One of the things we have, okay, what is the relationship of the child to the defendant?
Stepson.
Do you understand you cannot have any contact with this person, the child? Do you understand? See, here we go. There it is. There it is. Oh, I didn't know. Yeah, everybody knows. And that's why these cases get to trial, because of the influence that's being done. We find over and over again, they can't help themselves. They can't follow the rules. You cannot have any contact with a victim. That's across the board. But I know what happens. You get with them, before you know it, then the children feel guilty about your charges, because you're communicating with them, or people on your behalf are communicating with them. That's a condition of bond. It's always been. And he can sit out in jail.
Your Honor,
He can sit it out in jail until we get to this. It happens over and over again. And yeah, I'm going to stand up for people who are complainants when the rules say you shall not do that. But we know a child is being influenced here. It happens over and over again. They can't help themselves to try to change the facts. Then I want a jury trial. You know, nobody really wants a jury trial with these facts. When somebody says, oh, I want a jury trial, unless it's an unusual situation, it's always the same result. They have communicated and gotten the poor child to feel guilty about everything and change their mind.
But Judge, that's irrelevant to this case. This is a case in which CPS investigated it, and they made absolutely no finding of it. And this is not a case in which it's really irrelevant as to what the child.
What in the world did what did the grand jury use on whim to indict then?
They indicted that there was some bruising on the child, therefore they indicted him on the child.
That's not a crime to have bruising on a child. I'm sorry. They said he intentionally and knowingly caused bodily injury to the child.
Which is what I'm talking about on the bruising.
And by striking the child about the head and body with a cord or belt or unknown object.
And that's, we disagree with.
I don't care if you disagree or not. You can't have contact with the victim. And he's having contact with them. That's the point. Let's get to the ball here. You're in jail. You violated a condition of bond. You cannot have contact with the victim. And don't say, oh, I've been indicted now for going on 2 years. Nobody told me that.
Well, when you
I want to know who was responsible for not telling the defendant that that's a condition of bond. It's the common conditions of all bonds set by the criminal district courts. You can't have contact with the victim. Who told you you could?
Well,
I want to know.
You asked me if the kid was what relationship. I said it was my stepchild.
I said, are you having contact? Yeah.
Well,
You said yes.
Sometimes I go home and pick them up from school, and then
I don't care what you do. You can't have contact with the child. That's Are you going to interrupt me too? That's what you do, isn't it? You're in control of the situation, of all your situations. When you're charged with a crime, the court is in control, not you. And I set the court orders. You defy them when you contact the child. And I don't care what kind of contact you want to call it. But when it's contact over time, then I know what happens. The child is encouraged to feel guilty about being in the middle of this. The poor children are like a taffy pull. I know. I'm sure that this is terrible. I mean, the child has bruising on the around the neck and the upper body, and according to the grand jury, they allege you struck the child with something. But the point is you're looking at up to 10 years in prison. You don't have contact with the child. Give me the conditions of bond. What's his bond amount right now? Thank you. And this is our bond conditions.
$1,000.
Then our bond conditions. This is bond conditions you're subject to. Number 3, read that out loud. Read that out loud. Read it out loud to me, sir.
The defendant shall not communicate either directly or indirectly with the alleged complainant, victim of the pending offense, nor shall the defendant go near any residence, school, job site, or other location frequented by the alleged complainant.
How long you been picking up the child from school again?
I don't pick him up from school. Sometimes he goes home.
I don't care.
And I have to be there.
Did you just read that?
Yes, sir.
You've been doing that. You've been violating that.
He stayed in Colorado.
I don't care where he stays. You can't have contact with him, and you told me you were.
I understand. I'm sorry, my bad.
Your bond is revoked. And in fact, you can't be trusted to have any contact.
And there it is, bond revoked. Translation: the defendant's going back to jail until trial. The judge basically says, I don't trust you to follow orders, so I'll make sure you can't break them. Fair move, or too harsh.
I'm not going to give you a bond. You're going to sit this one out until we get to trial, which could take a while. But you want a trial, you got it. But you're also not going to be in control of the case. The court's orders are controlling. You have been violating this by subjecting a young child to a difficult situation by refusing to follow the court's orders. And I know what happens. It causes over time the child to completely change her or his version of the offense. They feel guilty about it. But it's not supposed to be that way. Children aren't supposed to be put in a situation like that by manipulation. And that's what you have. You manipulate the child. I just seen a picture. The child is scarred.
Judge, I'm not sure he received a copy of those bond conditions.
Then somebody else will be held accountable. But this or the court's orders on file for record. All defendants are subject to knowing them. And if the bondsman or their attorney fails to help them out with that, then maybe it's their fault. But all the defendants are subject to being accountable to these terms and conditions of probation, of bond.
Well, my point being is if he did not receive.
Ignorance is not an excuse.
Well, as a matter of due process,
it's on the court record. You're held to what's on the court record. And you've been his attorney for how long?
I don't know that.
Well, the attorneys ought to be advising them if there's a doubt about it. Maybe they ought to be helping them out. But the bondsman, if they're doing their job properly, they make sure that the defendant knows about it. But it's on file.
I understand, but Judge, he cannot be held accountable for something he was not aware of. That's a due process argument. And so we're asking the court to he knows about it now. He will not have contact.
Wait a second. Hold on. Okay. Let me just agree with that. Let's play like I agree with that. You've opened the door for 5,000 people to go, I wasn't aware of this. What's good for him is good for everybody. Either you're held accountable to knowing about it, and I'm not supposed to be the one that hands it to him. The bondsman and the attorneys. But it's on file. But what's good for one is good for. I open the door, every one of them will be lined up from here to Orange County. I'm on bond, and I didn't know. Nobody told me that these bond conditions were what they were, and so I want the Elvin Bryant rule. He was ignorant about it, and so am I. So, can you cut me some slack too? In all fairness, no, I'm not going to. Period. In the ball game, you're held accountable, and he's got buffers. It's not like him alone. He's got a lawyer. He's got a bondsman. My God, how can everybody drop the ball? The only thing is a child is in harm's way. A violation of the court's direct order is in harm's way. And he's been palling up with him. And we know what's happened.
Judge, your bond conditions are posted on the court's website as well. They've had been since they were created.
I haven't gotten to that yet. Yeah. So it's on the court. It's on the record. It's on the website. The bondsman, and if you want to get the bondsman involved with them and have them come up here, we're happy to have a hearing. And I want the bondsman to explain that he didn't go over those with him, and then I'll hear it. But I'm sorry. I opened the door for this, and everybody is going to say the same thing. I was ignorant to it. Sorry, I didn't know I wasn't supposed to do that.
Well, Judge,
And then we put what precautions, I supposed to be the one that delivers to them? No. Guys, that makes me so angry because we can't run this railroad by doing that. We have to have people understanding and appreciating the rules and following the rules. And here, he should have been aware of these rules by at least 3 different people.
yeah, well, I would, my contention would be that, there should, that I assumed that the process, that the system that was intact was that any bond conditions, the bondsman did in fact would go over them with him. That was my assumption. I would ask the court under these circumstances. I understand the court's ruling, and I'm not arguing with it. I'm just saying if the court would consider raising the amount of the bond rather than no bond at all. And if you're going to put him in jail, allow him to make a bond.
He's been on bond for how long?
He posted a bond in April 25th, 2023.
Do what?
Okay, yeah.
April 25th, 2023.
We're going on 2 years.
Yeah.
On 2 years that he's had quality time there to have contact with the child, and
Which my visiting with this client, Judge can assure the court, had he known that he was not supposed to have contact, he would have complied. He has been to my office every time I've asked him to come to my office. He is a productive citizen in terms of working, supporting his family. We would ask.
Let me ask you, you've heard the term ignorance of the law is not an excuse. You've heard that,
Yes.
right? How do you apply it in this case? I'm sorry, the rules are posted, and they don't have to be given to anybody. When they commit a crime and they're arrested, the answer to them, well, I didn't know injury to a child was a crime. Well, you're saying due process. I'm sorry, the due process does not work as when you're caught with a crime. It's up for the law enforcement, the accuser, to show that you had notice, that you knew about the offense. We all know that doesn't apply. It's the same application in bond rules, and we can't do much more than have a bondsman who I believe their proper method is ensuring that the bond conditions are followed. But I don't know if they go over them or not, but we post them. They're on the record. And everybody knows. And as the attorney, it's always a wise idea, I think, to ensure that the defendant is not following the bond conditions. But Mr. Smith, as an attorney, you know what these bond conditions are. It's on the record. You deal with them all the time. And if you've talked to the defendant, you know he's stuck contacting with it. He's contacting. I mean, he just blurted out. He's not hiding it.
No.
You had to know that.
Well, Judge,
And
we're
you're
asking,
aware of you are aware of the rules.
well, we're asking the court to
Hmm.
you revoke the bond. We're asking the court to set it higher. That's punishment.
How do I undo the time he has spent almost 2 years now having contact and influence with the child? How do you undo that? And how is that fair for the state of Texas?
Well, it's not remedied by putting him in
It
jail
isn't.
with no bond.
It's not remedied by, don't do that again.
Well, no, you're punishing him by making him post a higher bond.
How do I keep him from contacting the child when he was ordered not to in the first place?
What I'm advising the court is with my experience with this young man is that now that it's clear in his mind what the rule is that he will not have contact.
So that's the test now. From now on, I got to make it clear for every defendant.
Not at all.
Well, that's what you're saying.
No, I'm just
That's
saying.
the get out of jail free card.
No, not at all.
That's exactly what
I
it
don't.
is.
I understand what the court's ruling is, and I understand revoking the bond. I'm just asking the court to allow him to continue to support his family and make a higher bond. And that is in my mind, that is a sufficient punishment for him violating the court rule.
What's state say?
Judge, I think you pretty much reiterated the things that are most concerning to us is that since the inception of this indictment, he's been communicating, contacting the complainant in this case. I'm not quite sure how that's any less clear. I think either doubling the bond or no bond, both are in the realm of reasonableness.
18 years now I've been doing this, and this seldom happens because people know what the rules are. But it does happen regularly, almost, in family cases. It seems to come up over and over again.
Can we hold for a second, Judge? Judge.
Yeah. I'm listening.
Counsel's telling me that he's 90% disabled from the military, has had a traumatic brain injury, is dealing with PTSD. We have a veterans court, as you know, that could possibly benefit everybody in this, that might help out the situation as far as getting him treatment to where this doesn't happen in the future.
Yeah,
Yes, and that's what
the interests of the child are foremost. I mean,
yes, sir. Yes, sir.
That's
So what?
Sad for him, but nonetheless, the child is our foremost.
What I propose to do today is possibly, why don't we get a GPS monitor, put him under home confinement, except for work, and keep him from that address
Where's he
where
work?
the kid is.
Where does he work? Where do you work, sir?
Appliance repair.
What did you say? What kind of repair?
Appliance repair.
Who do you work? Is it individual?
Yes, sir.
Independent? Charles, Bruce, is the child in his home?
No,
Where's the child?
the child stays with his mother. I have a son.
You have a,
I have a son that
you're not
stays-
living with the mother?
No, I have a son that stays with me. So I go over there.
You can't have any contact with that child until we can get this resolved. Do you understand?
I understand.
All right. What else, Stephen?
That's it, Judge. I think that the no contact and if we get a GPS monitor on him, we can do home confinement, except for work and home.
Well,
Final twist. Instead of sitting in jail, the defendant gets a GPS ankle monitor and home confinement, a modern solution. But here's the real question. Does technology actually keep victims safe, or is it just a digital leash?
I don't care about the home confinement.
Just as long as he
It's
doesn't
no
go near that
contact with
address.
the child.
Okay. We'll
And,
just do that then.
that's that's the foremost, but how do we make sure he doesn't have contact with the child?
Well-
We may need a GPS device.
Right.
But
I
he
thought
doesn't need
that's
to be on
what-
home
Get
confinement.
the GPS have it within 24 hours. You can get it.
All
Comes out
right,
of
that will be a condition of bond, an additional condition of bond. We'll get to the bondsman in 48 hours. He needs to have a GPS device. And again, no contact with the child until we can get this resolved.
Yes, sir.
All right.
It's a, yes.
Okay, get a resetting.
Yes, sir.
Yeah, we need to put on Monday, put it on docket for Monday to make sure that he's got the GPS up by Monday, okay? All right, we're in recess.